Welcome. I'm Nikki Jovicic from LookUpStrata and also the Managing Director of Tower Body Corporate, a Queensland body corporate management company. I'll be your host today, and we welcome back Leanne Habib from Premium Strata. We're speaking about the bylaw breach process. Who needs to comply with bylaws, and why is it crucial for your owner's corporation to enforce them? We'll delve into the procedure for enforcing bylaws, including who may enforce them and how, and Leanne will also speak about whether penalties and fines can be imposed. Today's session will cover the stages from an initial warning letter through to the most extreme cases of obtaining fines of up to $5,500 from NCAT for a breach of orders. We'll also address the strict timeframes for enforcement. We'd like to remind everyone that this is a New South Wales session and any reference to legislation is specific to the state of New South Wales. Before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and the chat conversations, is not legal advice and should not be relied upon as legal advice. And you should always seek independent advice before acting on the information contained in our sessions. We're delighted to be joined again today by Leanne Habib from Premium Strata. Leanne is the co-founder of Premium Strata, and she's a licensed strata and community manager and a real estate managing agent with more years in the property industry than she cares to admit. Having previously worked in various senior management roles with large strata and community agencies around Sydney, Leanne has cultivated a niche in the eastern suburbs and the North Shore. As diverse and expansive as her experience is, the one thing above all else that has been the focus of Leanne's professional life is her clients. Ensuring their best interests are served and their outcomes are achieved continues to be a driving force behind her management initiatives. A member of Strata Communities Australia and a dynamic, forward-thinking professional, Leanne is committed to offering a level of service unmatched by the industry. And that's what makes Premium Strata a truly outstanding strata and community title management agency. And we welcome Leanne again, and it's really great to have you here with us.
Thanks, Nikki. It's always great to be back online, and I understand we've got quite a few listeners today, which is always exciting. It's good to know that we've got many listening, so it's all worthwhile. And yeah, very excited about today's session. Bylaws, it's always a hot topic in every strata scheme. So it has various moving parts to it, and I'm excited to talk about that today. All right, we're going to go through how we enforce bylaws. All right, so I'm going to start off with just explaining what are bylaws, and I'm sure most people know, but I thought there's no harm in explaining what bylaws are. They are rules which regulate a building and its occupants, and they are important to ensure that we have order. I always say wherever there's shared living and community living. I touch on more on its purposes shortly. But why are bylaws enforceable? They're enforceable because they're an obligation. And a lot of the times committee members will ask us, do we need to enforce the bylaws? And I always say yes. So bylaws are not a choice. They are rather an obligation. Owners corporations should always enforce the bylaws, because if you don't, that's when you find you start losing control within an owners corporation or shared living and community living. So it's very important that members and owners understand that bylaws should be enforced at all times. They are a statutory contract. It's not a choice, but it is an obligation to ensure that bylaws are enforced. Who's bound to comply with the bylaws? So there's various parties, including the owners corporation, of course, but your owners, your occupiers, and any mortgagees in possession. As I've touched on, that bylaws, are a statutory contract which bind each of the above parties. And really, it's as though that, they've signed the bylaws, which is why it's a requirement that bylaws are attached to any tenant's lease. So they are aware of the bylaws. And when you're obviously buying into an owner's corporation, bylaws will always be registered on title. So any owners doing a search will also be aware of those bylaws. So bylaws, like I said, are bound by 4 key parties. And occupiers and owners also have that duty to ensure that their visitors also comply with the bylaws when they come to the building, visiting them at any time. So what is the purpose of bylaws? So bylaws may be made in relation to the overall management of the scheme, administration, the control, the use and enjoyment of lots. And we generally refer to them as an exclusive use common rights property bylaw. But it's also, to ensure that, we are governing the keeping of pets, noise, parking, where they can have their laundry, whether they can smoke on the common property, whether they can make any changes, the type of blinds they can have to ensure that we're maintaining consistency throughout the building. Others, if everybody just went off and did what they want, then you're never going to control and have consistency throughout the building. So it's important that you've got bylaws that govern the use of the common property, even if you've got, shared facilities or common utilities and amenities such as the pool, the gym, the tennis court, you have bylaws to regulate the use of them, hours of use, behavior around, when you're using the gym or when you're using a pool or sauna, etc. But one key thing to also be mindful is if you're passing bylaws, you need to ensure that they remain consistent with the Act. You can't pass a bylaw that contradicts the Act. If you do, it will have no force or effect. So it's very important. So for example, you couldn't have a bylaw to say you can't have children under the age of, 10 in a building, because that would be prohibited by law. So it's very important that any bylaws that you are passing or implementing for your scheme, they are in keeping with the legislation, in particular the Strata Schemes Management Act, and generally at law. So why is it important to enforce bylaws? It's to have order. It's, to clearly establish guidelines for what is and isn't permissible within the building. It's to ensure the proper behaviour of residents. Some examples will include smoking on the common property, and I touch on a case study about smoking and how it interferes with the useful enjoyment of another lot later on in the presentation. But it's also to ensure that, we're governing the noise, where people are parking, to ensure, as I said, appearance of the lot. So we're not having people, putting up pink blinds, another resident having red blinds. So it's very important to have bylaws and enforcing them to ensure that things remain under control. I always say to my team, it's having cars on a road and having no road rules. It'd be chaos. And it's very similar in a strata scheme. If you have bylaws, it's important to enforce them. If you're not enforcing them, things are going to be out of control. And that's when you lose, control of the management or control of, the scheme as a whole generally. So how are they enforceable? What is the procedure? Now, the first two steps that I'm going to go through, they're not compulsory, but I always find it's important to start with the first bylaw breach letter. And the reason why, so setting out a warning letter, and it's something that you can either do as a secretary, your strata managing agent can as a delegated secretary, or your building manager can also perform that role by issuing a first bylaw breach letter. But I think it's important to send this bylaw breach letter, even though it's not compulsory, because sometimes you find the offender is not aware that they're creating a noise, and as soon as you bring it to their attention, they comply. That's in a perfect world and the ideal scenario. But you've also sometimes got the scenario where someone could say, actually, it's not me, I'm hearing the same noise, or I've actually seen the same car park in my car space, so I don't actually own that vehicle. So I think starting with the letter can always assist in clarifying who the real offender is. So I'd always start off with the first bylaw breach letter. I then give the courtesy of a second bylaw breach letter. And that is generally issued within 7 to 14 days after issuing my first bylaw breach letter. I don't send any more letters after that. It's the first and the second letter only. You could, if you wanted to, send a third, and depending sometimes what the breach of bylaw is, you may want to issue that third bylaw breach letter just to sort of, give that offender one final time to comply, especially if it's a bylaw that is a bit grey and a bit hard to sort of confirm who is actually breaching it. Then step 3, for me, I go straight to issuing a notice to comply. And issuing a notice to comply has a very specific form, and I've got a screenshot of what that form looks like. It's on the left of the screen. It is a prescribed form issued by the secretary, and that's the secretary of the Commissioner of Fair Trading. So it's a form that you can find very easily online. And a notice to comply does need a formal resolution authorising its issuance. So it's not something that can just be issued. Generally, if you've given that power to your managing agent under the agency agreement, they can issue it. And we have that as a power under our agreements, but we always have our team pass a resolution just for certainty and confirmation. So I strongly encourage that the Strata Committee convene a meeting, whether it's in person or by paper, to actually pass a resolution to issue this notice to comply. And that is just to ensure that you have that proper authority. You need to ensure to complete the notice to comply correctly and accurately. And it has to be witnessed and signed off by a JP. I did get caught out many years ago, and probably my first couple of years in Strata, so going back 23 years, where I completed a notice to comply. I did have it witnessed by a JP, but I forgot to have the second page dated. And I went to tribunal because this tenant didn't comply after receiving the notice to comply. And unfortunately, I got turned away over a technicality of the second page not being dated. And that's something that I've never forgotten. And it's something that every time my team issues a notice to comply and I sign off, I'm checking and I'm advising my team, make sure that second page is dated. So I guess it's something that you learn one time and you ensure not to do it. So it's just one tip that I'm giving everyone. Ensure everything is properly dated and accurately completed. Have that resolution authorising you to issue that notice to comply to ensure that there is no technical hiccups when you do get to tribunal if you do have to enforce compliance beyond this point. So I'm going to touch on a little bit on who can actually issue the notice to comply and how that all works. So an owners corporation can issue the notice to comply, as I touched on. It can, having that resolution either at a general meeting or by the committee. In most cases, you will do it at a committee meeting because it's a lot easier and quicker to call a committee meeting. And the notice to comply must contain a copy of the bylaw that we're alleging has been breached. It's very important to clearly set that out. So it's almost like when a staff member is being reprimanded for failing to perform its duties, you would give a letter of reprimand and you would clearly identify what they haven't done in terms of the employment contract or KPIs. It's the exact same concept with a notice to comply. If you're knocking on someone's door and saying you've breached this bylaw, you need to clearly articulate how have they breached the bylaw, when did they breach the bylaw, give dates, give times, give an example, but also set out the bylaw that they have breached so that they're made aware of the bylaw that you are saying they have breached. It's very important to do that. An owners corporation has the powers to enforce bylaws if it is satisfied that an owner and occupier has breached that bylaw. But again, it comes back down to being able to substantiate and having evidence that they have breached the bylaw. It's not just a matter of the committee or owner saying, Mr. Brown in Unit 101 has breached the noise bylaw. You have to be able to substantiate and prove that breach. So what happens if the breach continues? So this is, in most cases, in particular, if it's a breach that, an occupier doesn't want to comply with. And I say again, we all have a driving license and we have points. We get our first infringement. We don't stop. Unfortunately, sometimes we're unlucky and we get another infringement. Same thing with bylaw breaches. You're going to have occupiers that don't like to do the wrong thing, and you have others that are immune to doing the wrong thing. And for them, breaching a bylaw doesn't fazzle them at all. So after you've done your first bylaw letter, your second, you've issued the notice to comply, you still don't have compliance. The next step is to apply to NCAT, which is the tribunal, the National Consumer Arbitration Tribunal, for a penalty and compliance orders. So you want to apply to NCAT not only to get orders for them breaching the bylaw, but you also want to seek orders for them to comply with that specific bylaw. And sometimes there could be a breach of bylaw. For example, they've carried out unauthorized works. So in this case, I'd be applying for 3 orders. I'd be applying for a penalty. I'd be applying for compliance with that bylaw, but also seeking orders to have common property reinstated, or whether or not you want to accept the renovations but have a bylaw passed ratifying the acceptance of those works, etc. So it's very important to work out what orders you are seeking to ensure that you include in your application for penalties or other compliance orders. And I'm going to touch on about the penalty units and penalties further on. So are there time limits for seeking a penalty? Yes. So you have to do that within 12 months of issuing the notice to comply. So when you issue the notice to comply, you have up to 12 months. If that occupier continues to breach the bylaw in the first 12 months from issuing it, then you are in a position to make an application for a penalty. After 12 months, you would have to then reissue another notice to comply. So it's very important to monitor whether or not that occupier is complying after you've issued the notice to comply, just to make sure that you're within that time frame to then apply for a penalty and orders. So proceeds of penalties, that's the hot topic and question for a lot of committee members. Who actually receives, the proceeds from penalties? It's actually payable to the owners corporation in most cases, but it is obviously up to the tribunal to make that determination. And there could be times where it's not payable to the owners corporation. But step 4 is applying for application to the NCAT orders. So, you can apply for mediation first, and that is part of the process. And if there's been a breach of bylaw, of course, you apply for mediation first. And then if there is no result achieved in mediation, then you would proceed to actually applying for the orders and penalties that we spoke about earlier. So a breach of an NCAT order can result into a fine up to $5,500 payable to the owners corporation in the event it relates to an overcrowding. So it's a lower threshold, which I'm going to touch on if it's just a general bylaw breach. The maximum is $5,500, but that is relevant only to overcrowding. So a breach in relation to overcrowding within a law. So I'm just going to summarize the steps that we just walked through just to make it easier, clearer. It's up on screen. You can visualize it. Your first step, as I said, start off with the first bylaw breach letter. And that for me should be issued as soon as the breach is reported or is known. Step 2 is issue your second bylaw breach letter, and that's generally within 7 to 14 days of issuing your first. And then step 3 is to issue a notice to comply within, I would say, 14 days. And the reason why I say within 14 days is you need to have that time to convene your strata committee meeting. As I said, you probably want to do that by paper because it's quicker if you can't get everyone available. But by all means, you can still have that in person if members feel that they want to discuss it. I always suggest as well having the motion detailed. So when you're actually passing a motion to issue a notice to comply, detail the breach that that offender is breaching, detail who the offender is, and include dates and times in which they have actually breached that bylaw. And sometimes it could be a very big log. So what we do is we refer to it as an appendix to the agenda. So we would say, that, Mr. Brown in Unit 101 has breached, bylaw 4, noise, pursuant to the log attached at Appendix A to the notice of meeting. That's what we would do. Going to step 4, that's when you apply to NCAT, penalty and compliance orders. So they're your 4 main steps. I'm going to touch on what happens if there's a breach after a notice to comply is issued. Well, if they've issued a notice to comply, you've gone to NCAT, you've successfully proven to NCAT that yes, there is a breach. Remember what I said, it's not just our word versus a lot owner or an occupier, but we have to prepare a submission, there's witness statements, affidavit statements, etc., to actually prove that there has been a breach of bylaw. And that's why that log and that time log is very important, which I'll touch on a bit more later. So the first penalty is up to 1,100. And that's if the application is made within the first 12 months of the notice to comply. What happens if the breach continues after NCAT issues a mandatory penalty? So if they have received the first fine of 1,100, you'd go back to the tribunal and you would say to the tribunal they're still breaching, even though you've given them orders to comply with the bylaw. Then the tribunal can order a further penalty up to 2,200, so 20 penalty units. And each penalty unit is $110, and that's set out into the Crimes Act. It's not something that's actually prescribed in the Strata Act. They actually get those penalty units from the Crimes Act of New South Wales. So in this case, if you go back, you're up to 20 penalty units, so the maximum is 2,200. And then as I touched on before, you can get up to 50 penalty units, which is 5,500 maximum, or 11,000 in the relation to overcrowding restrictions only. So how do we apply for mediation or NCAT orders? So basically, mediation's for free. There is no application fee. It's easy. You fill out a form. And generally, there's no legal representation unless all parties consent to. So if it's a straightforward matter, you may feel that you don't need legal representation. If it's more complex, you may feel the need to have legal representation. And generally, that's only permitted if all parties consent to it. After you've attempted mediation and whether it failed or mediation was declined, you're now in that position to then apply for the NCAT orders. And there's a small application fee to do that. That's $222 for the Owners Corporation. And then if the Owners Corporation is successful for the breach of bylaw, then again, you could then apply for the penalty orders that I've spoken about. So some helpful hints. For me, it's keeping a log of dates. That is so important because, as I said, you get to the tribunal, you're going to go in the witness box, you're going to be providing witness statements. You have to be able to prove that there has been a breach of bylaw. It's not just a matter of saying it. So for me, keeping a log of dates, recording the times and duration of the breaches, where you can and where permissible by law, take photos, take videos. I'm not encouraging, of course, members or owners, trespassing on anyone's lot to take a photo or video. But if you're in a position that you can take it lawfully, then I would take that because that, helps the argument. That is the proof. It's very easy to then provide a photo proving the breach of bylaw. So if it's a car in a car space, you would take a photo of that car. You would have the vehicle registration details and so on. Have those photos date stamped, but also have a log because it just makes it easier when you do need to compile all your evidence and your application to NCAT, you've got all that information handy. So we generally keep, a bylaw breach register where you know, the first offence, second offence, and so on. We're putting that all into a register, and that will assist when we do put our application together, but it also assists briefing a lawyer if lawyers need to be involved and engaged, and they've got all that information that makes their submission a lot more stronger and easier to put together as well. So as I said, all of the above has a lot of weight to prove the owners corporation's case, and in most cases, the owners corporation will be the applicant, so the onus of proof is on the owners corporation. So it's important to ensure that, you know, you have all that evidence and all that information compiled very well and thoroughly and detailed. So I'm going to go through a case study. This is actually one of my case studies, and it's in relation to a very, very large tower. It's about 500 lots. And this tower's designed like a 360-degree tower where balconies wrap around and they're all stuck together. So we had a tenant complain of another tenant smoking, and she was severely impacted by the smoking that was causing her a lot of distress, but also health implications. And this tenant was alleging that smoke was coming from the adjoining lot over the balcony, but it was quite substantial, like it wasn't just a little bit of smoke. So after going back and forth, yes, we started our first bylaw breach, we started our second, then we had the property managers involved, and I always issue my bylaw breach letters to not only the offender, but if the offender is a tenant, I would issue it to the managing agent, and I would also issue it to the owner. When I do issue it to the owner and agent, I always ask them to confirm receipt and confirm what action they are taking to ensure that their tenant is complying with the bylaws, because that is their responsibility as a lot owner. I don't just send it to them as a FYI. I always have a call to action. Please confirm receipt and confirm what action you are taking. So that's very important as well. So in this case, we did copy in the owner and the managing agents, and we had the agents come back and saying, my tenant is not smoking. This is the alleged offender. And of course, we are now the meat in the sandwich. We have one tenant saying, yes, that unit is smoking, and we have the other tenant denying any responsibility or that they are breaching the bylaw and smoking. So I said, okay, well, I've got no evidence before me to determine who's actually telling the truth or who is the offender and who isn't. I'm going to call a meeting on site. And that meeting, I asked for the property managers to be present. So they are there on behalf of their tenant, the tenants as well, and the building manager. We attended site. We discussed the smoking concerns. And then the tenant said, I'm not smoking. It could be what I'm burning. It was a burning scent. And I said, but the other tenant saying she could smell a tobacco smell. So obviously in that session, we couldn't say one was lying or one wasn't telling the truth. But what I decided to do was we were going to determine a process to then have other witnesses attest to the smoke. So we could determine, is it just one tenant being sensitive to smoke, or is it really at that level where it is a disturbance and it is tobacco smoke as opposed to just burning a scent? So the resolution and the outcome was basically we would go and record each time there was smoking smell. We wanted the tenant who was impacted by it to contact the building manager to come up and actually smell or witness the smoke, because it's very hard to video smoke because it doesn't show in a video and it's very hard to take photos. So I said, okay, to this tenant, every time the smoke is there, I want you to contact the building manager, and the building manager will come up to smell the smoke. After hours, where a building manager isn't on site, it was agreed that they will contact the on-site security. And I know this is a large tower, so it had building management, it had a security after hours. But if you're a small scheme and you don't have those services in place, then I would suggest that a committee member take on that responsibility, being one or two, where a resident can contact those committee members. They could come up after hours and witness, or even during hours if you don't have a building manager, and witness the smoke. And that's exactly what happened. The building manager did attend because the smoking didn't stop. And it was this tenant's boyfriend who was living there. So he wasn't on the lease, but he was just constantly smoking, didn't care. And of course, if you're a smoker, you want to smoke inside your house, but he was actually smoking on the balcony. So the building manager went up when the tenant did report, I can smell it, come up now. He was able to confirm it was not a burning scent, as the tenant was trying to say. They could smell the smoke. So that then gave us more evidence to then enforce it further. As soon as we then enforced it further, the tenant vacated. And that is because the owners corporation was persistent in saying that we weren't just going to buy the story that you weren't smoking. It was, we took one step further in trying to prove it. And we had others that would witness and testify that, yes, we could see tobacco smoke coming from that balcony lot. So that I felt was a very good outcome, and it's something that I have implemented on other schemes facing similar issues. We do take meeting notes. They weren't formal meetings of the Owners Corporation, of course, but it was an informal session with the relevant parties where we did take notes, and in those notes we did confirm what was agreed. What was agreed by tenant 1, tenant 2, and the property managers. So it really did help, because the property manager for the offending tenant realised very quickly that their tenant weren't telling the truth, and that's why they then gave them notice to vacate. So it was a very good outcome. That's all I have, Nikki. So I'm happy to take some questions or go over anything specifically in more detail if our listeners had any specific question.
It was really good to hear the case study, Leanne. I really liked that you popped that in there to give a practical example of how it can work and how it can work positively. So that was really good, and great outcome for you too. That was excellent. And you touched on during that the importance of keeping really good records. And we recently spoke to Brenton Pittman, who was a gentleman up in northern New South Wales who took a matter about smoke drift to the tribunal and was successful eventually, though it did take a long time for him to do that. And one of the things in that video, which we'll share the link to everybody so they can watch if they haven't seen it as yet, was that he took what the tribunal member called meticulous evidence, and he had a logbook that he had noted down every incident that they'd smelt smoke, what they felt like when they smelt it, what else was happening, the direction of the wind blowing at that time. And I think he had about 800 records that he put into his spreadsheet and took to the tribunal. And it was very hard for the respondent to respond to that in any way, because the records were just so detailed that he provided, and he attributes that to his success in that case. And the other thing I just wanted to touch on, if you're the lot owner in the building and you're smelling something like smoke, or you're hearing excessive noise from the residents upstairs, or you're having trouble with people parking in your parking spot, I know in a lot of times when we've sent questions to strata professionals around Australia, one of the first things they recommend they do is to have a conversation with that person that's causing the breach. Do you believe that's a good action to take before you actually contact the committee as a lot owner, or do you think you're best to contact the committee as the first step?
It depends on the nature of the breach, because some breaches can be quite personal or sensitive. So I always encourage you think about what the nature is, and if you are, how you approach them. And I would always suggest, if you are approaching them, it's more like, look, you might not be mindful, but I'm hearing, the washer throughout the night. Is it possible that, you could perhaps, have the dryer on throughout the day and not at night time? So it's always approaching them in a more polite manner, rather than, your dryer's, creating a disturbance, and why do you have to have your dryer on throughout the night? So one, it's how you approach them, but it's also the type of breach, because some things are quite sensitive as well. But I always think that, if they don't comply, depending who that neighbour is, because if it's an owner, you might have more chances. Sometimes the tenants, don't necessarily react as positively as an owner. And I'm not saying that it's always the case, because sometimes you get tenants that act more positively than an owner. So I guess it also comes back down to, do you know that owner? Do you know that tenant? Because you don't want to create any friction, and you've got to turn up every day and, to your house. So you don't want to be feeling awkward in the lift when you're in the lift with that person, or in the lobby with that person. So think about it, and depending what it is would be my advice.
Okay, thank you. Thank you very much for that. The lot owners in the apartment above my unit installed a noisy floating floor. Mediation was unsuccessful, and NCAT ordered the floor to be replaced with carpet. The owners took no action. They were then fined, and they paid the fine, but they took no other action to replace the flooring. They were then taken back to NCAT and fined again. And once again, they paid the fine, but have not replaced the flooring. The owners feel it's easier to pay the fines rather than replace the noisy floating floor. And as the downstairs owner, what action can I take?
Yeah, and you will get owners that feel it's easier to pay the fine. This is obviously more of a legal question. So what I would be suggesting is that you do get the legal advice, but what I would be getting legal advice on is whether or not you can now apply for new different orders along the lines of getting an order to have the works carried out on behalf of the lot owner, the offending lot owner, at their expense, of course. Some implications with that would be access to the lot. So that would have to, form part of the advice. But obviously the first orders they're not complying with, I'd be looking at getting different orders to actually get the result of having the works completed, and also looking at another jurisdiction. perhaps going outside of NCAT and maybe going to another jurisdiction and seeing whether or not they have more weight and force. But it's definitely a legal question, and I would encourage that listener to actually get legal advice on it. And hopefully a little bit of the feedback that I've given on what advice you should be seeking is, one, what other orders can I seek? And really you want to be looking at orders to actually have the works carried out.
Okay, so in that situation, is it up to the committee to actually get legal advice and pursue the matter, or is it up to that particular lot owner?
That's a very good question. So it would have to be, in my view, I would think that the Owners Corporation have that obligation because the breach of bylaw is noise, and the Owners Corporation have an obligation to enforce compliance with the bylaws. But obviously it wouldn't harm having the lot owner who is being offended a joint applicant, so it has more force and weighting. So I would definitely be saying, in my experience, again, it's a legal question, but I would think it's the Owners Corporation.
Okay, thank you. In 2021, our scheme updated our bylaws to include a bylaw concerning the approval process for installing air conditioner units. Our strata manager provided all owners and property managers with a copy of the updated bylaws. Since the bylaw update, we've had multiple occasions where owners have installed air conditioning units without following any of the instructions outlined in the bylaw. What measures can be put in place to make sure this doesn't happen, and can the committee pass on the fees incurred by the strata for additional administration, etc.?
Yeah. Unfortunately, it's very hard to have a measure in place to ensure occupiers comply with the bylaws. You're always going to have, in every building, you're going to have a handful that will breach the bylaws. So I think my response is going to be focused on what measures and steps you can implement to address when someone does breach a bylaw, in particular renovations, and aircon's quite a familiar one. So the fact that they've installed the aircon doesn't mean you have to accept it. So I would then be implementing measures on how you can identify who has installed AC without approval. And that could be a matter of committee members having the eyes and ears on site, looking to check if anything's been installed that you haven't approved as a committee. So reporting AC systems when they're installed, and then pursuing that lot owner to comply with the bylaw, even if it's retrospective. So it's a bit like a DA. Everyone applies for a development application with council, but then in the instance where a landowner hasn't applied for a day and have done works, council get you to complete a building application. That's for works that have already been carried out. So you can still force the owner to apply for approval, and if they don't, then you'd be enforcing them to reinstate the common property and remove the addition to common property. So I would be suggesting committee members stay on the alert. 2, you enforce and pursue that lot owner for unauthorised works, being the installation of air conditioning, and then ensuring that those works comply with the bylaw. And if they don't, ensure that they do, and basically take steps to have a bylaw to ratify any additional works that they have carried out that doesn't fall into your current bylaw. In relation to the cost of the administration, that's a very interesting question, because I know that there was a case back in August 21. It was the Roden case, actually, where the court upheld a PET application fee. But I also know of other cases where there are bylaws passed to control communications and charge, lot owners for receiving communications that wasn't upheld. So my advice would be, you have to ensure that any application or administration costs are reasonable to ensure that they're enforceable. But again, such bylaw, I would believe you'd need legal advice to ensure that it's worded to ensure that it is enforceable. So there have been some cases where, tribunals upheld some administration fees, and there's been other cases that I'm aware of that haven't.
Okay, thank you. If the lot is leased and the resident breaches the bylaw, whose name do we place on the notice to comply? So I know you've talked about this a little bit in your case study that you had there. So is the notice sent to the resident of the owner, and should the lot owner be held accountable for the occupant of their lot? To further complicate the situation, the person on the lease does not live at the address and the resident is the one breaching the bylaw, and the situation relates to a nuisance that affects several lot owners in that it interferes with their peaceful enjoyment of the lot. So it sounds like it's a similar situation to the one that you explained in the case study.
Yeah, definitely. So you always have to issue the notice of breach to the offender, and the offender is who you know and is on your roll. So they're either on your roll as a lot owner or as a tenant. So if it's the owner that's breaching the bylaw, you'd issue it to the owner. If it's a tenant, you'd issue it to the tenant. If it's the tenant's partner, I would still be issuing it to the tenant, because they are responsible as an owner or a tenant to ensure that the visitors of their lot do comply with the bylaws. So I would be issuing it to the tenant in that case, but I would also be bringing the whole process to the owner's attention as well and joining them to any proceedings. Whether they are legally responsible or not, I would still join them, because I always feel putting pressure on the lot owner will also force their hand to consider giving termination of that lease. Otherwise, if they're just banking the rent and they don't have the headache, they're likely just to let it go. So anytime I'm enforcing bylaw breaches, I always involve the owner, regardless. You want to bank the rent, that's fine, but you need to ensure that your tenant is not causing a nuisance to others, but you need to be accountable. And that's also a great area too. So for example, my understanding is that the limit of an owner and accountability of an owner is them taking reasonable steps to ensure that their tenant is compliant. You can't hold an owner liable for the tenant breaching the bylaw, because they're not physically controlling those actions. But you can make them accountable to the limit and to the extent where they are taking steps to ensure that their tenant is compliant. Are they issuing them separate letters? Are they having their property manager speak to them? Are they having a meeting with their tenant to say, why are you breaching the bylaws? You've been notified that this is a breach of bylaw. So for me, that's where I feel that the owner's accountability stops, but you can't hold an owner responsible for action that are not carried out by them.
Okay, and in the case study, when you mentioned the call to action that you put and the breach notice as well, I thought that was a really great point for people, so that you're kept updated as to what's happening as well.
Absolutely, yeah.
So in January, February 2023, a lot owner carried out renovations, which were seen and heard by residents, including a strata committee member. There was jackhammering heard on multiple occasions, building dust and debris left on common stairs, building materials stored in the garage, and seen being carried into the lot by multiple workmen over several weeks. Unfortunately, the lot owner's only response to requests from the strata manager to submit an application and bylaw for approval was to say they only laid tiles over the existing bathroom tiles, so it's not a major renovation. If the OC proceeds to seek orders from NCAT, will the lot owner have to prove they didn't disturb the waterproofing when the jackhammering noise suggests they did, or is the burden on the OC to obtain witness statements?
That happens quite a bit. You always get renovation works happening and the jackhammers go off and then the phones ring hot, so-and-so is carrying out renovations. So, and if they're just telling you we're just put tiles over tiles, my response will be thank you. The Owners Corporation now requires an inspection of the lot to determine the extent of works carried out and if any of those works impact the common property. So I would not first be taking the response of that lot owner. I would have a separate meeting arranged with committee members, and depending on the extent that we believe has been carried out, I would have an expert present to have the building expertise to assess what looks like an addition alteration. And I would have that inspection first. That inspection would allow you, and we do this quite a bit, that would allow you to identify what works have been carried out. When you've identified what works are carried out, then you know where jurisdiction for the Owners Corporation sits, what common property has been impacted, what powers that we have now to have those works either reinstated, ratified by way of a bylaw, and so on. So once you've established that, I will then take the next step of writing to the owner and saying, following inspection, we identified that you have done A, B, and C in terms of works. These works do impact the common property. We're therefore seeking waterproofing certificates. We're seeking this, we're seeking that. You set out everything that you need in terms of plans. And the intention of the Owners Corporation is subject to receiving all these documentation, having an expert review them to ensure they're all in order, is to pass a bylaw to ensure that these works remain your responsibility, future lot owners' responsibility. Because the only mechanism to transfer liability and responsibility for alterations to common property from one party to another, in particular from the Owners Corporation to a lot owner, is by way of a bylaw. So the ultimate goal for an Owners Corporation in a situation like that is to get a bylaw to accurately reflect the works and define the works to the extent that they've carried out, so that you're ensuring if there is any issues with the works moving forward, in particular if they did jackhammer, as alluded, and 100% they would have compromised the membrane. You can't jackhammer tiles without interfering with the membrane, although I'm not an expert, but that's obviously very obvious. Then you want to make sure that that new membrane that they've installed, if they did, or no membrane that hasn't been installed, creates water penetration to the unit below, that the Owners Corporation are not responsible for that. So it's very important in that situation that you do get a bylaw. But to get to the bylaw, you need to identify the works they've done, and inspection is the first step.
Okay, so then the question went on to say, if the OC is successful at NCAT, will orders include that the lot owner reimburse the OC's cost? It will probably cost around $3,000 for the strata manager to compile evidence and documents and attend the NCAT hearing.
Yeah. Unfortunately, in the tribunal, in most cases, it's a no-cost jurisdiction. It's not to say you can't get it. It is extremely difficult, and I've probably seen it in my career happen maybe 3 to 4 times. It's very difficult. So I'd probably say you're unlikely to get costs, but you could. But I wouldn't base it on that, because whilst it might cost $3,000 to get all the information together, and it could cost even more to run it if you are getting legal representation, depending on how complex, the circumstances are, you have to look at it as a long-term liability. So for me, it goes back to my earlier topic as well. You have to enforce the bylaws. It's not a choice, it's an obligation. And 2, you want to look at the consequences. If you don't, those consequences would impact the other lot owners, because they would be potentially paying for a failed membrane or issues that these works create and arise in future for other lot owners.
Okay, and then finally, they asked if the NCAT does not generally award costs, it would be cheaper for the OC to just pay for preparation and passing of the bylaw, making the lot owner responsible for assumed renovation. So is that feasible? So you've answered that question anyway.
Yeah,
and
that
then,
could be that. So yeah, sorry, Nikki, that could be a compromise where the owners corporation does pay the cost of the bylaw if they wanted to, as the character say, look to the lot owner, but they don't have to. But that could be a compromise.
Okay, if the OC took that option, can the cost of the bylaw be on charge to the lot owner?
Well, if you're taking the option to pay for it, then you wouldn't be able to on charge it to the lot owner without their consent. But I think it's important to note too, even though, let's say this owners corporation takes the position of we're just going to do the bylaw and pass it, it's going to have no force or effect, because you need the written consent to the making of the bylaw and the passing of the bylaw. So in other words, remember I said the only mechanism to transfer responsibility from one party to another party is by way of a bylaw. I, as an owners corporation, can't just pass a bylaw and say, Nikki, you're going to be responsible for that bathroom. I need your consent accepting that liability and responsibility. So you're going to have to get these lot owners' consent regardless of cost, because they have to give written consent to the making and passing of a bylaw for it to be registered and have any full force or effect.
I'm a residential lot owner in a mixed-use strata complex with 33 residential units, 10 retail lots and multiple commercial suites over 3 buildings. There are 2 strata plans, strata plan residential and strata plan commercial and retail. Overall, it's managed by a building management committee, and the same strata manager manages both plans. So over the past 15 years, there have been serious issues regarding unapproved installations or works on common property. Can the residential executive committee issue a notice to comply with a view to escalating the notice to an enforceable NCAT notice to comply against one of the retail lots? And if not, what are the appropriate processes to follow, and what role should the strata managing agent be playing in that situation?
All right, so I can see from the information you read out, they're part of a BMC, so it's a stratum lot. I don't know whether or not this breach is in shared areas or common property of one of the owners corporations. So I'm going to cover both options. I'm going to first address if it's a breach on common property within the retail owners corporation, then everything I've spoken about today will apply. You can issue the notice to comply, take the steps that we spoke about, escalate to an application to NCAT, and in that case, you'd be seeking an order for penalties, an order also for compliance, whether you want them to reinstate the common property or have a bylaw ratifying the approval of their works. If, however, the assumption is it's actually, works carried out by a retail lot owner in shared areas, then the SMS, which is a strata management statement, that is the governing document that is the overall arch over the BMC, you'd have to go back to your strata management statement and see what mechanisms are in that document to enforce, action on one member. Like we've got a scheme at the moment, I won't name the scheme, but you had one member that made changes to some arches and the other member wasn't aware of it and they didn't go to the BMC to get consent. That's a hot topic at the moment between these members because they didn't go to the BMC and get the consent, although legal advice was those arches were the responsibility of one strata member. But the fact that it's responsibility of one member doesn't mean you wouldn't go back to the BMC to get resolution, because if you're changing the architectural feel of the overall building, then you need all members to be in favour. So in this case, if a retail lot owner has carried out changes to their retail lot, okay, which is the first scenario, but those changes impact the overall aesthetics of the development as a whole, then you might have the residential owners that are concerned with that change. So in a lot of community schemes or BMC schemes that we manage, whilst we get approval on the strata level, being the owners corporations level, we still, depending on the application and renovation works, we still take it to a BMC level. And the BMC level is more focused on giving its consent to ensure that they feel it's in keeping with the overall development. Because if you had every strata member within a BMC running off and doing what they wanted, then it's going to start looking very tacky as a development. You know, if the residential scheme allowed their owners to have pink blinds and the commercial had purple blinds, it's going to start looking out of shape. So that's why the BMC sits on top and controls the architectural codes and changes to the building as a whole. So hopefully I've answered that for that listener, because the question wasn't, from my perspective, definite whether or not it was in shared areas, it was impacting on the architectural feel of the building, or whether it was just common property and changes within that law.
Okay, thank you, Leanne. What to do if the person that's breaching a bylaw is on the committee, or it's actually the committee that's breaching the bylaw?
It is a hot topic, but I have a hard approach, sorry to say it, but for me, rules apply to everyone. And I always say to my committee members, just because you're on the committee doesn't give you a license to not comply. The rules are for everyone, and you would be putting the owners corporation in a position for a lot owner to take action against an owners corporation. And they could even be applying for compulsory appointment where they can prove that the owners corporation is breaching one of their duties, and one of their duties is to enforce compliance with the bylaws. So for me, I go back to my earlier comment, it's not a choice, it is an obligation. Regardless who is breaching the bylaws, everyone should be treated equally on the same platform. If you're on the committee, I would highly recommend that you don't breach the bylaws. And if you do want to breach the bylaws, then I'd highly suggest that you reconsider your position on the strata committee, because it's not one leading by example, but you're also putting your owners corporation in a very awkward situation. So that, yeah, that does happen, but we have, and I think it comes back down to leadership too. We would say to our committee, look, I understand you're on the committee, but I do need you to comply with these bylaws for these reasons. You don't want to be in a position where owners are going to the tribunal because you're not demonstrating and complying with bylaws. So I think it's understanding what the consequences are if you don't.
What about offensive noises from industrial fans that are non-compliant?
Okay, so again, you would still enforce a breach of a bylaw about noise and any other bylaw that you could sort of throw in. Because remember, when there's a breach, sometimes it's one or two bylaws that you can actually insert, and then you can get a penalty per bylaw rather than just, you know, overall. But I would then also look at other authorities, engaging other authorities such as, you know, councils, and seeing where compliance isn't met and having other authorities step in to give you more weight and more power. So don't just rely on the bylaw enforcement, but also rely on other authority enforcement.
Can OC formal resolution to issue notice to comply be decided by committee email vote?
I would say no, because a resolution of the strata committee is not by email or not standing in the lobby or by phone, but it's by a properly convened meeting. And if you're going to do it by email, it will be as simple as doing it by paper vote, because you would complete the ballot paper and submit that via email. So I would say no.
Okay, thank you. And we've been asked what bylaws apply for smoke alarms to be repaired by the tenant or the strata manager.
Okay, so depending if they're battery operated, if they're hardwired, I wouldn't encourage making that the responsibility of the tenant, only because you've got other implications and so on back to the FIP panel. But if they're battery operated and you want owners to be responsible for the smoke alarms, then you'd have to do that by way of a bylaw. And then I would further suggest that they pass a resolution that de-invests the responsibility of the owners corporation. But in order to pass that resolution, the Act is very clear that you can only do it if it doesn't create an issue for others if it's not maintained. Because what that is doing is the owners corporation is passing a resolution to say, as an owners corporation, we're not going to be responsible to change batteries in a smoke alarm. I don't think they'd be able to do it in this case, because if no one else maintains it, then that's a safety issue. So I also wouldn't be encouraging having a bylaw to make batteries the tenant's responsibility, because fire measures always stop with the owners corporation, because the owners corporation is responsible to submit annually the annual fire safety statement, and you're going to need those smoke alarms to comply in order to get your certification. So I personally would not be recommending having a bylaw to make smoke alarms the responsibility of lot owners. I would always keep that under the control of the owners corporation. but you could have a bylaw if they did want to.
Okay. And we've also been asked, do you need an overcrowding bylaw in order to issue a notice to comply and set penalties and compliance orders?
You don't, but there's no harm in having one because it's more definite. But I would strongly encourage having one because then you've got that bylaw that can set out the rules. But there is, restrictions around overcrowding generally, but having a bylaw in more detail, as long as it's in line with the Act, is no harm. So it is a good recommendation.
And that brings up the question as well. Like, it's really important to have a look at your bylaws as well and make sure that they're relevant. Some buildings have really old bylaws that are no longer relevant. They might not have gone through the review process.
Yeah, absolutely. We just took over a couple of schemes and one large one in particular, and their bylaw is still saying no pets. And there was changes where you can't say no pets, but you've got to, provide reasonable approval and consent. So in other words, you can't unreasonably withhold consent. So I think it's very important that bylaws are reviewed regularly, whether they're done annually or I think is fair. Every 6 months I think is an overkill, but every year I think it's a good idea as a committee, just run your eyes over it. Of course, things change, behaviours of residents change. So sometimes you think, okay, you've got very comprehensive bylaws, but there's always something that you don't have a bylaw for. So I think it's important because having the bylaws allows easier enforcement, but it also helps residents and occupiers, etc., understand what the bylaws are. What are the house rules? What do I have to comply with if I choose to live in this building? So I think it's a good way of making residents aware of their obligations if they do take up occupancy in a building.
Just to have that conversation. And the situation that I spoke about earlier about the gentleman on the north coast of New South Wales that enforced that smoke drift situation, they didn't have a smoking bylaw, and that just made his situation so difficult. He had so many hoops to jump through before he'd even gotten to the level playing field. So it is really important to have those bylaws in place.
Yeah, because the case study that I shared, Nikki, they did have one, and that made it a lot easier.
Yes. Thank you very much. And Leanne, we'll see you at a future session.
Thanks, Nikki. Enjoy the day.
You too. Bye. Thanks. Bye. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.